Hello, everybody. This is Bob Probst with the Probst Law Firm in Winston-Salem, North Carolina. Today is another day of the Wednesday Live on Facebook at 4 o'clock. Today is July 29th, 2020, and the subject for today's discussion is DWI laws in North Carolina. DWI meaning driving while impaired laws in North Carolina. We're going to do this in a couple of parts. Part one today, we're going to talk about just the overview for driving while impaired laws. We're going to talk about reasonable and articulable suspicion. We're going to talk about probable cause. We're going to talk about the investigation, and then we're going to talk about the arrest. Then in part two, next Wednesday, we'll talk about sentencing and punishment. In North Carolina, the sentencing is determined by certain factors determined in your case. It can be very complicated, and depending on which level you're sentenced at, depends on how much trouble you're in and how much time you can spend in jail. So part one today is just going to talk more generally about it, what an officer can and can't do, what's going to happen if you're pulled over and investigated for probable cause for driving while impaired, and what's going to happen if you're arrested for driving while impaired. Next week, we'll talk about sentencing and punishment. So let's just get to the general overview of driving while impaired in North Carolina. If you are driving on a public roadway in North Carolina, you are subject to the laws of North Carolina. And one of those laws says you cannot operate a motor vehicle on a public roadway while being impaired or appreciably impaired by some sort of impairing substance. Could be alcohol, could be drugs, could be illegal drugs, it could be drugs that were prescribed for you. That's right, you can be arrested and convicted of driving while impaired, even if the reason for your impairment are drugs that were prescribed for you by a doctor. But today we're going to talk mostly about alcohol impairment, because that's certainly the majority of cases in North Carolina where people are arrested and convicted and sentenced for driving while impaired. So let's say you're driving down the road somewhere in North Carolina. It could be day, could be morning, could be afternoon, evening, night, doesn't matter. And what is it that could get you pulled over in North Carolina? What is it that gets you pulled over in North Carolina that an officer then could use to investigate whether or not you're driving while impaired? The standard for pulling somebody over while they're operating a motor vehicle in North Carolina is reasonable and articulable suspicion, often just called reasonable suspicion. And all that means is that an officer has to have reasonable and articulable suspicion that a crime has been committed. Reasonable meaning taking in all the circumstances that the officer knows, taking in the training that the officer has, and articulable means he can describe them, he or she can describe them, that he can list the reasons for deciding to pull somebody over. It's not probable cause. It's a much lesser standard than probable cause. It's a very low bar for pulling you over. No pun intended, since we're talking about DWI laws and bars generally. It's a very low bar for them to pull you over. So let's go over some examples. An officer can pull you over for suspicion of a traffic violation if you are traveling under the speed limit. Most of the time people think of, well, if I'm speeding, they'll pull me over. If you're going under the speed limit, that may be a reason to believe a crime has been committed. That is driving too slowly, and you can be pulled over. You can be pulled over for reasonable suspicion that you're driving over the speed limit. You could be pulled over for reasonable suspicion because you didn't use your blinker as required to change lanes or to make a turn. Or because you turned too widely when you were making your turn. You could be pulled over for reasonable suspicion because your car drifted over the yellow line and back. You could be pulled over because your car is drifting within your own lane back and forth. You could be pulled over for reasonable suspicion because you have a brake light that's out or a tail light that's out. You could be pulled over for not using your blinker. You can be pulled over because you sat too long, in the officer's opinion, at a red light after it turned green before you went through the light. So you can see really the low bar it is for officers to pull you over. You kind of get the picture. If he thinks you've done anything that violates any traffic law in the state of North Carolina, they can pull you over. Now, once they've pulled you over because they have reasonable and articulable suspicion that you have been violated a traffic law, during that investigation for that offense, let's say speeding or changing lanes without using your blinker or something like that, running a stop sign, anything really. During that investigation, the officer may also form probable cause that you are driving while impaired. Reasonable suspicion and probable cause are two different standards. Reasonable suspicion is a pretty minor, low standard. Probable cause is a higher standard. Probable cause does not mean they have to have enough to convict you of the crime. It only means they have to have probable cause to believe that you have committed the crime of driving while impaired. So it may be enough to arrest you, but may not in the end be enough to convict you. That's a different standard. To convict you of a crime in North Carolina, the standard is beyond a reasonable doubt. We're not going to get into that today. We'll get into that next week. Right now, all you need to know is if the officers pulled you over with reasonable suspicion that you committed a crime, then they look to see whether they can show probable cause that you committed a crime of driving while impaired. So how do they go about determining probable cause? Well, first of all, you need to know it's the totality of the circumstances that the officer's taken in consideration, given the officer's training and experience as a police officer, and what they've observed you doing or not doing in some cases. And they take that in the totality of the circumstances. So, for example, they pull you over because you're driving too quick, too fast, or too slow. And they approach your vehicle and they come to your door and you roll down your window and they ask you for your license and registration. If you're fumbling in your glove compartment for your registration, that may be something they can use as a factor for determining you may be impaired. So I recommend you have your registration easily in a place in your glove compartment where you can find it easily. Because quite honestly, in the middle of the night or in the afternoon, any time of day, if you got to go through your glove compartment with all the junk that's in a lot of people's glove compartments, and it takes you a few minutes to find your registration, and maybe it's an old registration because you never threw out the old one when you got the new one, that may help him form probable cause. So have it in a place where you can reach it quickly and give it to him. If you have to fumble through your wallet or your purse to get your license, that may be a factor for an officer to determine that maybe they got probable cause that you're impaired. If they smell alcohol on your breath or anywhere in your vehicle, that will be a factor that they'll use. If you have bloodshot eyes, that will be a factor that they'll use. Now, many of us, me included, I don't know if you can see, who wear contacts, our eyes are bloodshot a lot of the time because we have contacts in. And that may be what's happening with you when you get pulled over as well. But along with the other factors we're going to discuss, an officer can use that to say, that's one of the factors I use to consider whether or not this person was impaired. If you have slurred speech, that is a factor the officer can use to determine that you probable cause that you've been impaired. If you ask you to get out of your vehicle and you stumble as you get out, that could be a reason that the officer uses as a factor to determine that he believes you're impaired. I've seen in reports officers talk about they only rolled down the window a little bit. They didn't roll it down enough for me to talk to them. That was a factor they considered. I've seen in officers' reports that the person was chewing gum. That was a factor that they considered. They could use what they observed about your driving before they pulled you over as a factor for considering whether or not they have probable cause to believe that you're impaired, like weaving in your lane, like going too fast, going too slowly, all those things we already talked about. These are all the things that the officer is going to use, taking into consideration their experience to make a determination about probable cause. But they can do some additional things as well, and they almost always do. They're going to ask you to step out of your vehicle. Then they're going to ask you to usually to come back to the back of your vehicle or to the front of their vehicle where they can talk to you some more. When you do that, they're going to observe how you got out of your vehicle. They're going to observe whether you had a lean on your vehicle as you were walking. They're going to observe whether you stumbled as you walked or whether you walked erratically while you were walking back to your vehicle or to their vehicle. They're going to observe about how you talked when you were talking to them. But there's also three other things they may use in determining whether there's probable cause that you're driving while impaired. And those three factors are what we call field sobriety tests. And they're field sobriety tests that have been determined by the National Highway Safety Traffic Authorization Organization, I forget the exact acronym, that they have found supposedly to scientifically show that someone may be impaired. And there are three of those that are used all the time in North Carolina and accepted by the courts as some scientific evidence of your impairment. The first one is what's called the horizontal nystagmus test. And basically what that is, it's a little bit more involved than that, but basically what that is the officer is going to hold up a pen like this. The officer is going to ask you to hold your head still. Don't move your head, just follow the pen with your eyes. And then the officer is going to move the pen back and forth, slowly like this, and watch your eyes as he does it. And if it's nighttime, he's going to have a light in your eyes. If it's daytime, he's just going to observe with the daylight. But what the officer is looking for in that test is whether your eyes jerk at certain angles of the pen. And by jerk, it's often described as like a pair of windshield wipers where the window's not quite wet enough, so you turn your windshield wipers on and it gets there and then it starts doing that and then goes and comes back and does that and then goes. That jerking motion is what the officer is looking for your eyes to do in that nystagmus test. Because supposedly, scientifically, if you're not impaired, you're going to be able to follow that pen with your eyes, and your pupils are going to move very smoothly back and forth. There's not going to be that jerking or stopping motion. They're also going to see, if you're following the instructions, if you're moving your head when they told you don't move your head, that kind of thing. But that test is called the horizontal nystagmus test. And they're going to write down on their report certain clues that they saw when they gave you that test. A second field sobriety test is called the stand on one leg test. And I'm going to try to show you a little bit, but basically they're going to ask you to pick a leg, your left or your right, stand on that leg, and then hold up your other leg, approximately 2 feet off the ground, and put your hands to your side. And they're going to ask you to hold that stance for a period of time and count out loud usually. And what they're looking for then are clues in that test, like you had to put your arms out in order to keep yourself balanced, or you were swaying as you were standing there, or you had to keep putting the foot down that you had lifted up in order to keep your balance, or you just fall off of your balance. So those are some of the clues they're looking for there. They're also, again, looking to see whether you can follow the instructions that they give you when they tell you how to take that test. Again, they're going to write down certain clues in their report that's going to be used later to testify with in court if they have to about how or why they use that to determine whether or not they had probable cause to arrest you for driving while impaired. The third use field sobriety test is called the heel to toe walk and turn test. And basically, again, what they're going to ask you to do is they're going to ask you to walk in a straight line. So maybe you're on the side of the road and there's a line marker there. But you know what? Sometimes there's not. They're just going to use an imaginary straight line. But they're going to ask you to take a certain number of steps, heel to toe, so that your heel touches your toe, which I know you can't see in this video, but your heel touches your toe with each step. So they're going to instruct you to walk heel to toe for so many steps forward on a straight line. Then they're going to tell you a particular way to turn around and come the same number of steps back, heel to toe, on a straight line. Okay? Chances are they're going to demonstrate that test for you in some way, but it's not going to be the whole test. They'll demonstrate a couple of steps, turn around a couple steps back. It won't be the test start to finish. And then they're going to ask you to take the test. And then they're going to observe things like, is your heel touching your toe? Heel to toe with every one. So is your heel touching your toe? Are you walking the correct number of steps that they ask you to walk? Did you count out loud the number of steps that they asked you to walk? Did you turn around in the manner in which they told you to turn around? And did you walk heel to toe, the number of steps back to the beginning? And they're going to, were you swaying? Did you step off that either physical straight line or imaginary straight line, which is crazy because who gets to see the imaginary straight line and that you stepped off of it? But that's how it's done. And whether you were able to follow the instructions. Now, they're going to take that test as well. They're going to write down some clues that they had to help them decide probable cause of whether or not you were impaired. Okay? So they're going to take that whole totality of the circumstances, how you were driving, how you acted when they approached the car, bloodshot eyes, slurred speech, staggering, fumbling for your license or your registration, how you answered their questions, odors of alcohol, and then the field sobriety tests. And then they may ask you to take what's called a instant breathalyzer test right there. Now that breathalyzer test, the result of it anyway, is not admissible in court. But they may ask you to blow into one right there on the street so that they can get a positive reading as well of alcohol on your breath. And then along with all the other circumstances, they use that to help them show probable cause to arrest you. So once they've decided based on the totality of circumstances, and every stop is different, every reason for a stop is different, and most every investigation for impaired driving probable cause is different, in the sense that not all of them have the same thing going on. You don't have the same clues. You don't have the same results. But they're going to use that and decide, I believe as an officer of the law that I have probable cause to believe that the crime of impaired driving has been committed by this person and that they are appreciably impaired. Once they make that determination, they are going to arrest you. There is no, hey, can you call my wife and have her come get me? There is no, hey, I only live like right down the street, can I walk home? There is no, hey, my friend's with me, can you just let him drive me home? They're going to arrest you for driving while impaired in North Carolina at that point. And what that arrest means is they're going to put the cuffs on you. They're going to leave your car parked off the side of the road where it is, and then they're going to put you in the back of their car, and they're going to drive you somewhere. Usually it's a magistrate's office. And oftentimes the magistrate's office is where, depends on the county, where they have a breathalyzer machine where they can do some further testing. When they get you to the magistrate's office, they are going to ask you to take a breathalyzer test using an atoxalyzer machine. The results of that breathalyzer test are admissible if done correctly. And There are some defenses that a defense attorneys can raise at that stage, but assuming it's done correctly, the results of that breathalyzer test can be used in court against you. Similarly, if you refuse to take that test, the results that you refuse to take the test can be used against you in court at the trial. Now, what does it take to convict you in North Carolina of driving while impaired once they've arrested you? They're going to arrest you. They take you to the magistrate. They probably have you take a breathalyzer test if you'll do it willingly. Sometimes they take a blood test. That's a whole different discussion maybe for another day. I could do a day on that. But they can force you or attempt to force you or get a warrant to take your blood if you refuse to blood. The other thing you need to know, and we'll talk about it more next week when we talk about sentencing and punishment, is if you refuse to blow the breathalyzer at the magistrate's office, or you refuse to give them blood if that's what they request, then you will lose your license under a different statute for up to a year. Each of us, when we get our license in North Carolina, sign a document saying, if asked by a police officer, we will give a breath sample or a blood sample when there's a suspicion that we're driving while impaired. Refusal to do that is a different statute, but it is a revocation of your license for 1 year just because you refused. Even if you're found not guilty on the DWI, your revocation is going to also happen, though, under a different statute for refusing to take the breathalyzer. But after the magistrate determines that, yes, there was probable cause to believe that you drove impaired based on what the officer tells them they observed, they will set a bond for you typically. And then if you pay the bond, you're able to leave. They may also, their bond may be you're able to leave when you sober up. So you may have to have somebody come and get you if you're too drunk to leave on your own. But they're going to set some sort of release orders for you. And then once you're out of jail, you'll have a court date later, but the magistrate will have told you when your court date is. So we'll talk about a trial and things of that nature later, but what you need to know, I guess, for this general overview is for a DWI conviction in North Carolina, the state has to show beyond a reasonable doubt. So remember before, it's just reasonable and articulable suspicion to pull you over. Then the standard was probable cause to arrest you for driving while impaired. Now the standard for conviction in North Carolina is beyond a reasonable doubt that you committed the crime of driving while impaired. Couple of ways they can show or convince a judge that you were beyond a reasonable doubt driving while impaired in North Carolina. One is if you take that breathalyzer or if you give blood and the results come back equivalent to you blew a 0.08 or higher on the breathalyzer, or your blood alcohol content from the blood draw is equal to a 0.08 breath alcohol content or higher. There's a presumption in North Carolina, that you are and were driving while impaired at the time. Now, the burden is on the state to prove beyond a reasonable doubt that you were driving while impaired. But if they can get that 0.08 breath alcohol content into evidence, now the presumption is you were impaired, and the burden switches to you to overcome that presumption, which you can do. It's difficult, but you can put on evidence to overcome, even though I had a 0.08 blood alcohol content, I really wasn't impaired. That's another probably talk for another time as well. But what's important to know now is if you blow a 0.08 and that's able to get into evidence, there's going to be a presumption that you're impaired, and it's going to be hard to overcome that presumption, and it's going to make a conviction that much easier. Now, let's say you refuse to give a breath test, or you refuse to give a blood test, so they don't have that as part of their evidence. Can they still convict you in North Carolina of driving while impaired? The answer is most definitely yes. Most definitely yes. They just do it a different way. They still have to show that you were appreciably impaired at the time you were operating the motor vehicle. But now they don't have a blood alcohol content test result to use against you. So they're going to use all those things we discussed before. They're going to use what they saw when you were driving. They're going to use what they learned from you during the investigation to establish probable cause and how you were acting and all of that. And then the officer can make a conclusion, give an opinion in court that you were appreciably impaired based on all those things he observed. If a judge believes that, a judge can convict you of driving while impaired, even though there's no blood alcohol content admitted into evidence. Now, admittedly, it's a little bit harder to do that, to convict you under that basis, but it's done every day in North Carolina. Don't believe for a second that just because you don't have it, they can't convict you. They can. It makes it harder and gives your defense attorney some more opportunities and weapons to use to defend you, but they can convict you of that. Now, the other thing to know is, at least in most jurisdictions in North Carolina, we all know most officers have body cameras now. Most everything that goes on out on that street during the investigation is probably being recorded. So oftentimes the officer will turn on their dash cam of their car when they get behind you and start recording what they're seeing before they pull you over. Then when they pull you over and they get out of their vehicle, they have their dash cam going, and then oftentimes they will usually they're supposed to turn on their body cam. And then their body cam records pretty much everything that they see, from their approaching the vehicle to asking you for your license and registration to giving you the field sobriety test to everything in between, right? And in most jurisdictions in North Carolina, your attorney can get those videotapes prior to deciding whether to try the case, prior to deciding what defenses you have. So the types of evidence that your attorney can get are the physical written report that the officer does that says, this is what happened from A to Z. These are the clues I noticed on the 3 field sobriety tests. This is the breathalyzer result or the blood result. And they can get the videos of what they were doing when they're following behind you to see how you were driving and of everything that happened once they pulled you over. You don't know how many times, and I know I'm not the only attorney in North Carolina has this happen, but I'll have a client come in and go, I aced those field sobriety tests. I know I did well on those. And then I get the videotape and we sit down and we watch the videotape, and of course they did horribly on them. Why would they come in and tell me they think they did really well on them, or they know they did really well on them, and then we get the video and we see they didn't do really well on them? Most of the time that can be explained by the fact that at the time they took the test, they were severely impaired. And their memory, their recollection of what occurred out there is different than what actually occurred out there because they were impaired. However, also, there have been times when me and other attorneys as well will look at those videos and we'll disagree with what the officer says those videos show. And we may want to play those videos in court and to defend that you're actually impaired. There are times when what we see on the video, in our opinion, does not add up to appreciable impairment. And we want to play the video in order to help you. Now, once you have a trial, and in North Carolina, that's in the district court level in front of a judge, at least initially, and the judge convicts you, then it switches to a sentencing hearing. And we're going to get into that more next week when we talk about sentencing and punishment. But here's a teaser for you to know. Question: can I be required to serve an active sentence in jail on my first offense of driving while impaired in North Carolina? In other words, I've never had a prior offense of driving while impaired. This is my first conviction. Is it possible? Can I be sentenced to an active sentence in jail? Answer: yes, you may. Yes, you can. there are factors that they consider, and there are some factors that automatically give you an active sentence even on the first offense. So come back here next week, a little teaser, and I'll tell you what for sure to make sure you never do if you've been drinking and you're getting behind the wheel. Make sure you never do this if you want to avoid an active sentence if you're convicted for driving while impaired at that time. Remember, North Carolina isn't a state that says you can't have any alcohol in your system. It's a state that says you can't be impaired, right? So if you decide, I'm going to take the chance and have some alcohol in my system when I drive, I'm going to tell you next week one thing not to do so that you can't be forced to get an active sentence if it's your first offense. One thing not to do to keep you out of jail, for sure, if it's your first offense. So that's sort of drive while impaired law in North Carolina, sort of an overview. Next week, we'll talk about sentencing and punishment. In the meantime, it should go without saying, do not drink and drive. Forget everything I just told you about what defenses you might have and what your attorney can do to help you. Just don't do it. It's not worth it to you. It's not worth it to your family. It's not worth it to someone else if you get in an accident because you've been impaired driving. It's just not worth it. And in today's time, you know, it used to be when we were younger, you had to call a cab, you have to wait. Now you call an Uber, call a cab, call a friend, call a spouse, call someone. If you've been drinking, just let somebody drive you home and avoid this altogether. It avoids the chances of you going to jail. It avoids thousands of dollars in costs. It avoids thousands of dollars in increased insurance premiums if you're convicted. Just don't do it. So that's my public announcement for today, I guess. I've done this 32 years now. I've seen what driving while impaired can do. I understand people make mistakes, and I'm willing to help people when they do, but best advice I can give you is just don't do it. So that's it for today. Stay safe, and as usual, peace to everyone. Thanks for watching. Hey, Doug.
Hi, Bob. How are you?
I'm fine. I just like 30 seconds ago finished. This thing went longer than I wanted it to, but oh well. It's what happens when I'm excited about the topic.